All right. Now, contract is fully formed because it's offered and accepted and has consideration, and both signers have the capacities, proper capacities to sign the contract. Contracts. If it's not performed, it can be, if it's not performed, it's usually a breach of contract, but there are times that it's not. When there is a condition precedent or condition subsequent. Repeat after me. Condition precedent. Condition subsequent. 어느 게 선행 조건인 것 같아요? Precedent. Yes. Okay. So condition precedent to formation. Repeat after me. Condition precedent to formation. Okay, well, to be exact, it's not really condition precedent to formation, it's condition precedent to effective date. Okay. Effective date. To effective date. Condition subsequent to effective date. Okay. Here we go again. Not data, it's date. Okay. So this means it's built into a contract. A condition precedent is built into a contract so that contract becomes effective only when condition precedent is satisfied. Okay. Well, what are those situations where contract does not become effective immediately but only after condition subsequent is condition precedent is satisfied? For instance, this condition precedent to a contract becoming effective is delivery to me, right? You'll often run into those clauses. You'll often run into those provisions in international business contracts, which means even if it's signed, okay, even if it's signed by the other side, unless it is delivered to me, okay, even if it's signed by both parties, before it is delivered to me, it's not effective. It becomes effective only when I get hold of the countersigned contract. countersigned는 이제 양쪽이 다 서명한 걸 countersign이라고 하죠. 왜냐하면 countersign은 마지막 하나 sign을 countersign이라고 하니까 countersign이 됐다는 건 양쪽 다 됐다는 거고. Okay. So why would you put a clause like that in the contract? That a contract does not become effective unless or not until I get hold of the signed copy. Why would you want that? Well, in Korean, if you are a cop and if you want to control your contractual relationship, or if you want to control when the relationship begins, you want to put in that clause. Because as soon as you get hold of the contract becomes alive, right? So as soon as it becomes alive, you already have a contract in your hand. Okay? There are times, now this is again true case. These are all real cases that I ran into. Again, this is a film company. Sold a movie to Spain. So Spanish distributor bought a Korean movie or he said he will buy a Korean movie. So there was a negotiation. So Korean distributor, Korean film producer signed the contract, okay, and sent it to the Spanish distributor who was supposed to distribute the film in Spain. But as soon as, after the contract was sent, Spanish distributor disappeared. Nowhere to be found. So now, Korean company is in a dilemma, right? Because Korean company doesn't know, your client doesn't know whether the contract has been entered into or not, whether it has been properly offered and accepted or not, right? Because your client doesn't know that, your client cannot begin finding other distributors. Because if the Spanish distributor signed it, then it's an exclusive contract, and if you license it to another Spanish distributor, you'll be violating the contract, right? What was more mind-boggling was that when the Korean film producer traveled Spain, he found that the Korean film is already being shown in movie theaters and out on DVDs. When the Spanish distributor didn't pay any money, right? Okay, so now, since the contract has, the Spanish distributor has to pay money, minimum guarantee, running royalty, so your client, wants to sue the Spanish distributor. And then there are different ways of filing international lawsuit, but arbitration is the most effective remedy, the most effective way of obtaining compensation. You want to do that, but you can do that only if you have a signed contract under which both parties agree to do arbitration. But your client doesn't have the signed agreement, right? So your client is obviously being injured here. 손해를 입고 있죠. And he knows that, your client knows that the contract has an arbitration clause because he signed it, kept a copy, but doesn't know whether it has been countersigned by the Spanish distributor, so cannot go forward to arbitration either. What's the only other option? Finding a Spanish lawyer and filing lawsuit in Spanish court, and that's not a pleasant experience. Finding a lawyer in a town that you don't know. That's not a pleasant experience. That's not only not pleasant, it can be very costly. Because everywhere you go, you get your acquaintance discounts from lawyers, if you know what I mean. Okay? And you don't get any of the discounts. Okay? So, a lot of times, you want to be the last one to sign the contract. Because as soon as you sign it, you know that there is enforceable contract at your hand, and you know the terms of those contracts, the terms of the contract right away. Now, if you are a cop in Korean language, if you are the dominant party, maybe you can just ask the other side nicely to sign first, right? And then sign later, right? But some other companies want to make sure that whoever signs first, they become the last possessor of, or the first possessor of an effective contract. So they put in a clause like this. Condition precedent to a contract becoming effective is delivery to me. Okay? So let's say it was signed on certain day, February 1st, and let's say it was delivered to whoever that me is. During that time, is contract valid? No, it's not effective. It's not effective. Which means, even though it was signed, even though it has been signed both parties, before it's delivered to me, either side can repudiate the contract. Either side can cancel the contract. Okay? Because it's not an effective contract yet. Okay? So that's condition precedent. What is condition subsequent? Condition subsequent goes like this. So here's point of execution. And then let's say there is a condition precedent, and it is satisfied here, becomes effective, right? Now, condition subsequent kicks in after it has become effective. Okay? So after it has become effective, condition subsequent kicks in. Now, if condition subsequent is not satisfied, contract becomes void at that time. Okay? So it's executed, but it's not effective because condition precedent is not satisfied. Now, when condition precedent is satisfied, it becomes effective. Okay? And then effective. Let's say condition subsequent is supposed to be satisfied on, say, 90th day. All right? And let's say condition subsequent is not satisfied by the 90th day. Then it loses effect. Okay? What are the types of condition subsequent? Government approval, usually. Okay? So usually the clause goes like, the effect of this contract is subject to a condition subsequent that government approves it, say, within 90 days. Okay? Which means on the 90th day, if the government hasn't approved it, it becomes void. Right? Now, what's the difference between condition subsequent and condition precedent? What's wrong with saying, hey, what's wrong with saying, hey, instead of saying government approval is condition subsequent, you could have said, hey, government approval is condition precedent. Okay? Which means if it's executed, when it's executed, it doesn't become effective until government approves it. Okay? And only when government approves it, it becomes effective. That way, you get rid of this limbo stage where the contract is effective, but you don't know whether it will continue to be effective, right? But if you do it this way, if you make government approval condition precedent, right, then it becomes effective only when government approves it. So there is no time where a contract is effective, but the government has not approved. So it's effective, but only semi-effective, right? It's effective only temporarily, right? You get rid of that uncertainty by government approval, subsequent government approval condition precedent, okay? Right? But why would you not want to do that? Why would you want government approval to be condition subsequent as opposed to condition precedent? Okay, I can see I am confusing you. I can see in your eyes. All right, let's do it this way. If it's condition precedent, you sign it, and then when condition precedent is satisfied, now it's effective. It's effective forever. Okay, let's say it's government approval. Now, if you make condition subsequent, okay, then as soon as you sign it, it immediately becomes effective. Okay? But when there is no government approval, if there is no government approval, okay, immediately effective. When there is no government approval, it loses effect. Okay? If it's a condition precedent, you sign it, not effective because this condition precedent is something that has to be satisfied before contract becoming effective, right? So only when government approval is given, it becomes effective. Okay? So as I said, if you make government approval condition subsequent, there is this limbo stage where contract is effective, but you are not sure whether it will become further effective or not, right? Because depending on what happens on the 90th day, it can go this way or it can go that way, right? But if you do the condition precedent, you sign it, but you don't have to worry about it, you don't have to think about it because it's not effective yet. Only when government approves it, it becomes effective. Okay? And there is no limbo stage. On this side, it's not effective. On that other side, it's effective forever. Okay? So there is no limbo stage. Why would you prefer to have conditions subsequent? Why would you prefer to have government approval as condition subsequent, not as condition precedent? Why do you want to have this limbo stage? What's the benefit of having government approval as condition subsequent as opposed to condition precedent? The benefit is this. As I said, condition subsequent means condition subsequent means something, if not satisfied, okay, something that if not satisfied will kill the contract, right? Which means before condition precedent is satisfied, there is also this limbo stage where both sides, either side, can repudiate the contract. Repudiate. 부인한다는 얘기예요, 부인. repudiate 하면은 캔슬이 되죠, 캔슬이. So both parties signed it, but they are not bound by any contract yet. Okay? Of course, if you think that you are being defrauded, you can file lawsuit for fraud, things like that. But you still don't have a contract. Okay? So that's the difference. between condition precedent and condition subsequent. Now, these are true condition precedent and condition. These are true condition precedent and condition subsequent. The ones that give effect to the contract itself becoming effective. But there are also conditions that are not so true. Okay? These are kind of quasi-conditions. What I mean is condition subsequent or condition precedent to performance. Repeat after me. Condition precedent, condition subsequent to performance. Okay. So it's a condition that has to be satisfied before either side has a duty to perform the contract. Okay? But for instance, so let's say you are selling me that notebook for say $1,000. Okay? You are selling me. Now my duty to pay you $1,000 is conditioned on your delivery of the notebook to me, right? So the contract can say my condition precedent to my payment of $1,000 is delivery of the notebook to me. Okay? So that really does not touch upon the contract becoming effective. So it's not as interesting as that. But and this is more like just obligations, contractual obligations, or just put contractual obligations in order. Who goes first? Who goes next? Okay. But then again, you will see a lot of M&A contracts that has this provision. Condition precedent to purchasers' obligations. What is purchaser's obligation in an M&A contract? Share purchaser's obligation. Paying money. That's the only thing. Condition precedent to purchaser's obligation is delivery of financial statements in a share purchase agreement. Share purchase agreement means shares of a company, okay, stock. Okay. In that agreement, delivery of financial statements. What are financial statements? Well, when you buy a company really doesn't exist in some massive concrete body, right? Company is just a paper, right? Company exists only in the form of a paper. The only way to know the value of that paper is by looking at financial statements, right? So, so many M&A contracts has that provision to make sure that purchaser has duty to pay only when the purchaser knows the value of the company. Okay. Financial statements, there are three kinds of financial statements. Balance sheet. Okay, you two should know well. You did statistics, you did economics. Okay. Balance sheet shows the assets and liabilities. It's a snapshot of a company, right? What's the other one? Income statement. Good. Income and loss, profit and loss statements, which is also income and expenses, income and expense statements. What's the third one?
Cash flow.
Good, cash flow statements. You did accounting or economics? Both.
I did both, yeah.
Okay, all right. Good. So this is example of a condition precedent or a condition subsequent to performance. Now I'm going into discharge. So we passed the stage of conditions. We passed the stage of both condition precedent and condition subsequent. Now contract is fully effective. But even after that, there are situations when a contract is not breached even when it's not performed. That happens when it has been discharged. When does it discharge? When does it get discharged? Well, the most frequent example is, repeat after me, force majeure. Okay. Majeure is like God, right? Force of God. What are we talking about? Natural disaster. Sometimes majeure means something supreme, right? Something above you. So it can mean also government. So force majeure at minimum includes natural disaster and act of government, meaning like government passing the law, right? Let's say I have a lease contract, okay, lease agreement, but the government passes a law that bans such a lease, right? Then the contract gets what? Discharged, right? Force majeure is the most frequent example of discharge. And if force majeure or discharge situation takes place before a contract is performed, often the parties can just cancel the contract. So go back to the pre-signing stage. Just act as if the contract never existed. But if force majeure happens after it has been performed, what should happen? Not cancellation, but termination. Okay? What's the difference between termination and cancellation? If you terminate, you don't go back. Okay? You settle. You settle as if the contract has existed, and you give respect to the contract. So if you haven't done anything, you have to pay things. If you're supposed to pay something, you have to pay. But that's termination. But if the contract is discharged, you are free from those obligations. Okay? You are not going back to the pre-signing stage. You give full credit to what has gone on up to that point. But when force majeure hits, both parties are freed from contractual obligations. Both parties are discharged from contractual obligations. Now, this discharge can happen contractually or by force of law, meaning by operation of law, right? Force majeure, usually it's a provision in the contract, but even if there is no such provision, even if there is no force majeure clause, these contractual principles can operate to discharge your contractual obligations. What are those principles? Repeat after me. Impossibility. Impracticability. Frustration. Okay. So impossibility is when, say, you are supposed to you have a contract to give someone a ride for $100 to, say, Incheon, but the government passed a law that bans giving someone a ride for a fee. Then it's legally impossible to do what you contracted to do. Then it's impossible. Okay? Impracticability. let's say the government did not ban giving others right for money, but the government increased the oil price so high that it's impracticable to give someone right to Incheon for $100. That may, I'm not going to say that will, but that may become a valid impracticability that discharges your obligation to give that right. Okay? Frustration. Well, what if the, let's say I contracted to give you a ride to Incheon, say 2020 on January 1st. But in the meantime, the government built a high-speed train between Seoul and Incheon. Something like that. Then the purpose of the contract is frustrated because now you can just get on that train and not need a ride. Okay? Now that may or may not become a valid frustration, but I'm just saying, you know, I'm just trying to describe what frustration is, right? So those situations, even if the contract doesn't say frustration, even if the contract doesn't say, hey, frustration applies here, right? Even if you don't have that provision, it will kick in to discharge you from those obligations. Okay, but most of the times people put force majeure clauses in there to make sure that there's impossibility, impracticability, frustration, all those things go in. All those things apply to them, right? So let's say there is a force majeure clause. But what does it mean? What if the contract just says force majeure applies? Is that enough? Usually not enough. At minimum, it protects you from natural disaster or act of government. But other than that, it's a fair game. You have no idea what will qualify as a force majeure. You know, the oil price increase, fuel price increase, it may or may not be force majeure. It may or may not be force majeure condition. What if your company has a labor strike? Is that a force majeure? You don't know. If you don't know and you want to be protected from it, you put in there. So there, the title of the provision will be force majeure, but you want to list whatever that you want to be protected on. A labor strike, exchange rate fluctuation, raw material price increase. Now, between supplier and distributor, who will want a stronger force majeure clause? Or who will usually want a long list of force majeure conditions? Supplier and distributor. Supplier. Because supplier has to go through a lot of hoops to make the delivery. Right? Good. That's discharge. Any question or comment? No. Good. All right. If a contract that satisfied all the conditions and has not been discharged, is not performed, if such contract is not performed, then it has been breached. Okay? If condition fulfilled and discharge did not occur, then contract must be performed, if not breached. But even at that point, there are concepts limiting breach. Okay? Repeat after me. Time to cure. So even if a contract has been breached, you are supposed to give the other side time to cure it. Okay? A lot of times it's contractual. Every business contract that you will deal with will have time to cure provision. So it goes like this. If a contract is breached, you have 30 days to cure. Okay. To be more accurate, it goes like this. If a contract is breached and one side gives the other side a notice of a breach, okay, so it usually goes in 2 steps. There's breach, and then the non-breaching party gives a notice of breach. And if the breaching party does not cure, this is the time to cure. If the breaching party does not cure the contract, it is permanently breached. Okay? So you can see that breach actually took place here, but legally it is, I'm sorry, not breached, but here, terminated. So it gives notice of termination. If the other side, if the breaching party does not cure within the time, then the non-breaching party can terminate the contract by giving notice of termination. So usually it requires giving 2 notices. And these are most important notices. These are 2 most important notices that your client don't want to do without you. Okay? When you write a contract for your client, one thing you should tell them is, if you're going to terminate a contract, please come to me. I'll give the notice of breach, I'll give notice of termination. Okay? I'll explain a little bit later why they always do this with professional help. Yes, question?
Regarding the notice of breach, the time to cure will start when the breaching party receives the notice, right?
It depends on what the contract says. I haven't seen, I don't remember clearly that much detail. But I'm sure the contracts I've dealt with probably says things like you have to cure the breach within 30 days of receiving the notice, right? Or other contracts may say you have to cure within 30 days of the date of the notice of breach, right? Which means the date of sending the notice. Okay? But I don't remember exactly what is said. I think either way is possible. Any question, comment? Okay. The second thing is, second concept limiting breach is divisible contract. Repeat after me, divisible contract. It's dividable, okay? So, for instance, let's say I ordered 100 pairs. 100 pairs of Birkenstocks, okay, sandals, okay. Let's say all the left sides of Birkenstocks came, right? So you have 100 lefties of a Birkenstock, and the other, the righties, the 100 righties didn't come. Can the supplier argue that they performed 50% of the contract and is entitled to 50% of the money? No. Okay, that's not divisible, right? But let's say they first sent in 50 pairs, 50 full pairs of Birkenstocks, and then didn't deliver 50 other pairs. Can they claim 50% of money saying they performed 50% of the contract? They can claim, yes. They may have a good argument. But depending on the contractual situation, that may not be considered divisible. But at least there is that claim. At least it is arguable. Okay? So that is the concept of a divisible contract, which means if a contract is divisible, if the other side breached here, the breach affects only that divisible part, leaving that other divisible part still valid. Understood? Okay, divisible contract. Second, there is there is a concept of the minimus breach. Repeat after me. The minimus breach. Or material breach. So it's the same thing. When a breach is not de minimis, it means it's a material breach. Also, the principle goes like, hey, only a material breach is valid breach. Valid breach sounds really weird. Only material breach is legally meaningful. Okay. So it's the other side. It's either side of the same coin. Okay. If it's not de minimis, it's a material breach. Okay. So, for instance, I was supposed to deliver to you 100 pairs of Birkenstock by January 1st, and I delivered to you past midnight on January 2nd. Okay? But your store does not open until 8 a.m. So I breached the contract technically, but it's a de minimis breach. Okay? It's not a material breach. In that situation, you have not breached the contract. Okay? All right. Now, there are times that you really want to get something on time. Okay? Especially in M&A contracts or financial contracts, handling millions and billions of dollars, even a day's difference or even an hour's difference can make a lot of difference in terms of interest and also opportunities for buying other stocks. Okay? And you really want to make sure that the contract is performed exactly as planned, then you put in a clause like this. Repeat after me. Time is of essence. So this is the concept of breach. Any question, comment? None. All right. Now remedies. If a contract is breached, now we can talk about remedies. Oops. Remedies. The non-breaching party can get three things, as I said. They can terminate a contract, seek for money, or ask for court order, right? Termination. One thing that you want to be very careful about termination is if you don't terminate correctly, even if the other side has breached first, if you don't terminate it correctly, you may be in a bigger breach and be responsible for more damages. Okay? The typical situations where that happens is wrongful termination. What is a wrongful termination usually in American language? Wrongful termination. Firing somebody. Okay? Firing somebody improperly. Terminating employment of someone. Okay? Let's say the employee did something wrong. So the employee was supposed to do this and that under the employment contract, but the employee failed to do that. So he was in breach first, but if the employer does not terminate him correctly, the employer will get sued for what? Wrongful termination. There are so many lawsuits like that. So now wrongful termination usually means wrongful termination of employment. Now the same thing happens between businesses too. Let's say you committed only a de minimis breach, but I send you notice of termination. Who is at fault? I'm at fault. I'm at bigger fault, right? I mean, you can make comparison to who is married here. Okay. All right. The wife made some mistake. What will be, and let's say I want a divorce. Okay. Who is more blamed later, say 10 years later? The wife that made a mistake or the one who said, I want a divorce? You. Okay? Terminating a relationship is much more serious remedy than, terminating a relationship is much more serious than making some mistake or breaching some provisions. So you want to do that correctly. You want to follow this two-step process exactly under the contract. So, there's nothing really profound about termination. I'm just giving you a tip that you want to remember when you go out in the field to represent your client. So this is something that I made up to remind myself what is important. Repeat after me. A wrongful termination is a breach of contract. See, when you are terminating, you are probably terminating because the other side has breached, but your termination can also be a breach of contract if you don't do it correctly, if you do it wrongfully. Okay? Next, damages. Liquidated damages. Repeat after me. Liquidated damages. What does it mean, liquidated damages? Liquid. What is a liquid? What is the most liquid thing of all? Or what's the liquid that people most want? Cash. Cash. Right? So liquidated damages means, let's say I suffer some damages. Let's say I didn't get this desk delivered to me by certain time. But I don't know what that damage means until you turn it into dollar terms, until you turn it into cash terms. So liquidated damages means you, in advance, give dollar terms on each type of breach. Right? For instance, if this desk is not delivered to me by, say, January 1st, I'll be paid $100. Okay? So you put those damages into cash terms in advance. That's liquidated damages. There's a term for that in Korean civil law too, right? What is it? 위약금 or 손해배상 예정액. Good. It's either or, right? So 위약금 is penalty. Liquidated damages is 손해배상 예정액. I'm sorry for those who didn't Korean civil law, but in the end, you don't need to know that because it's just the translation. Okay? I mean, it's like, as long as you know what apple is, you don't need to know what apple is in French. Okay? All right. Anyway, liquidated damages. Under Anglo-American law, liquidated damages, well, I'll say that again. Under Anglo-American law, penalty is illegal. Penalty clause is void. It's not enforced. Because the rule is that, the philosophy is that the purpose of contract law is to protect people's expectations. It's not to punish people. It's not to change people's behavior. It's just to give effect, to give credit to what people expected through this act of giving promises. Okay? So all you need to do as a contract judge is to restore people's expectations. Give the injured party what he or she has expected. That's the purpose of contract law. Contract law is not supposed to do any more than that. Let's say the other side has breached the contract for some selfish reason. Doesn't matter whether he did it selfishly or otherwise. All the judge can do is just give the injured party what the party was supposed to get under the contract, nothing more. Okay, so penalty is void. So when is something liquidated damages as opposed to penalty? Well, when these two conditions are met. First, okay, listen to me carefully. The nature of the contract is such that actual damages is not easily ascertainable. Okay, so nature of the contract is such that it's difficult to figure out how much the damage is. Okay. For instance, let's say I was supposed to be paid some money by a certain date, say January 1st. But the money was given to me January 5th, 4 days later. What's the damages of getting the money 4 days later? It's hard to figure out. It all depends on a lot of different things, right? So only in those situations, liquidated damages is recognized. But that's only one condition. The other condition is that after the contract has been breached, the amount of liquidated damages has to have reasonable relationship. The amount of liquidated damages has to have a reasonable relationship with actual damages. It cannot be, basically, the requirement just says the amount of liquid damages cannot be too big compared to what the injured party has suffered. Okay? So what does it mean, too big? Actually, that was my first assignment when I was a first year law school, to figure out where the drawing line is, where the line is drawn. I read cases, and many cases show that if the liquidated damages is like more than 100 times the actual damages, then liquidated damages was considered penalty void. But then I saw these cases where liquidated damages, say 5 times the actual damages, was considered not penalty. Okay? 5 times okay, 100 times not okay. How about 6 times? How about 20 times? I don't know. You just have to look through more cases. Okay. So one advice or one question that you will get a lot is your client will come to you and say, Attorney Lee or Attorney John, whoever, this contract is really important to us. We really want to make sure that the other side performs the contract faithfully. Let's put in a strongest penalty possible in the contract so that the other side doesn't even think about breaching the contract. Okay? Let's say it's a contract on million dollar machinery. Let's put in a clause. Let's put in a liquidated damages clause for say $1 billion. Okay. That way, the other side will never think about not performing. Will you say yes to that? No. Okay. If you say yes to that, it's likely that the actual damages will be, it's likely that that amount, $1 billion, will be completely out of proportion. Completely out of proportion with the actual damages. Okay? When that happens, the entire clause gets cut. It's not like Korean judges, when that happens, Korean judges settle for the middle. Anglo-American judges, they just void the whole clause. Then your client will valuable provision in the contract. Okay? All right. Second thing that you want to learn is consequential damages. Repeat after me, consequential damages. Who has studied Hadley versus Baxendale? Hadley versus Baxendale. Okay. This is a case from 1400 in England. Okay? All right. I might have lied. It might be from 1600. I'm really bad with the numbers. I'm bad with the history. I'm bad with people's faces. I'm not sure, but it's either from 1400 or 1600 in England. A mill, flour mill, stopped operating because a part broke. So flour mill operator ordered replacement part from a blacksmith. You all know what blacksmith is, okay? Blacksmith did not deliver the part as promised. There was a delay of 5 days. For 5 days, the mill stopped operating. So the mill sued the blacksmith for loss of revenues for 5 days. The court said that's too consequential. That's not to be recognized as damages. Okay? Those are not direct damages, but those are consequential damages. Those are damages that suffered as some remote consequence of not having the part on time. Okay? So that's the principle of consequential damages. So what are the consequential damages? Damages contemplated at the time of formation of the contract. Okay? When the mill ordered a certain part from the blacksmith, they didn't contemplate, the blacksmith didn't know that that part will actually stop the mill for 5 days. Okay? The damages that the mill suffered was not contemplated by both parties at the time of the contract. Okay? This happens a lot too in practice. One question that I got a lot is, say, SI company, right? System integration company, like LG CNS, that integrates software and hardware and builds a network for different businesses. And LG CNS was supposed to get some software delivered from, say, top software vendor like Oracle, right? The software came, it had defects, so LG CNS could not do the SI business properly for, say, 6 months. Can LG CNS sue Oracle for the loss of business for the 6 months? No. Okay? Because those damages, like how much business that LG CNS could have done or would have done, could not be reasonably contemplated at the time of entering into the contract. Okay? So normally loss of business is considered consequential damages and is not recognized. Is not recoverable. Okay? That's consequential damages. And okay, sure.
Consequential damages are usually not recoverable.
Usually not recoverable. That's the principle of consequential damages. That consequential damages are not recoverable. Now, I noticed that some scholars use the term different ways. That consequential damages are recoverable, and those damages that are not consequences of the breach are not recoverable. That's not how I learned. The way I learned is the consequential damages are those damages that are not recovered, because they were not contemplated at the time of entering into contract. So, many companies will come to you and wanting to sue the other side for, not delivering certain key products, key software, or key something, so that your clients could not do the business properly for a few months, but your client cannot recover the loss of business. What can your client recover? in Hadley versus Baxendale, the court said loss of business, no. But the cost of getting replacement, mill is entitled to this much, cost of replacement. So if the mill ordered the replacement part from some other blacksmith at probably a much higher price, because now the mill has to get a rush job, right? Say 10 times the ordinary price, then that much the mill can recover from the breaching blacksmith. Okay? All right. So one way to avoid the consequential damages rule is that write in liquidated damages provision. Okay? So many times in construction contracts, there are many construction contracts that have late penalties or delay penalties. Those are proper liquidated damages as long as the amounts are adjusted reasonably. That way, it works as liquidated damages, and it also forces the other side to contemplate the damages coming from delay, because the contract will say that, hey, if you are late by these many days, I'll have to pay late penalties of $1 million to the primary contractor. So you have to deliver the goods by a certain day. So now the late penalty I have to pay is contemplated in my contract with you. Okay? Yes.
So could we define the liquid damages as a pre-estimation of which?
Sure. But it has to be a reasonable estimate. Okay. All right. Good. Special damages. Repeat after me. Special damages. Special damages also has different meanings, but in the sense of special damages and general damages, it has the meaning of, special damages, repeat after me, special damages, general damages. When the term is used in this pair, special damages means specifiable damages. Okay? What does it mean, specifiable damages? The damages that can put it in dollar terms. Like, let's say you get into auto accident, the medical bills. You know how much you spent, okay? Right? Say, loss of wages. You know how much you did not make because of your injury, right? That's special damages, right? Here, loss of profits. This is different from loss of business over here. Loss of profit is something like cost of replacement, right? Let's say, cost of replacement is the same as loss of profit. This is a loss of profit. Profit here is profit of that contract, okay? Let's say Hadley was supposed to get the let's say the Hadley was supposed to get the part for $1, but instead he got the replacement for $10, right? Okay, 10 times. Then the cost of replacement is $9, right? Okay, but also you can say that this is a loss of profit coming from that contract, right? Hadley would have made $9 profit if Baxendale delivered the part on time, right? By not having to go for the more expensive part, okay? So it's that loss of profit. That's all considered special damages. Now, general damages are the damages that cannot be put into dollar terms, like pain and suffering. Pain and suffering. So when you get into an auto accident, you go to a hospital, you are treated, you go through pain, and you have to suffer, loss of motion, you have to suffer loss of enjoyment. Those things cannot be put into money terms, cannot be put into monetized terms. Those are general damages. Now, I put up there because most damages under contract law are special damages. No general damages for breach of contract. Okay? Let's say you breached the contract with me to deliver this desk by January 1st. You didn't do that. For some reason, I felt a lot of disappointment in you. No compensation for the disappointment I felt. Okay? Let's say I was insulted. No compensation for that. Let's say I was let's say I felt really lonely because you didn't deliver the desk on that time. No compensation for loneliness. Okay? But because I needed the desk on January 1st, I ordered a replacement desk from other place for a more expensive price, I'm entitled to that difference. That's all. And that is special damages. Okay? Now, there is other use of the term special damages. For instance, it can be used in this way: ordinary damages and special damages. So in Korean, 통상손해, 특별손해. Okay? And you know that 특별손해 is harder to prove or harder to recover than 통상손해. Okay? When special damage is used in that pair, it means what it means. But when it is used together with the general damages, this is what it means. Okay? Specifiable damages, damages that can be monetized. And most contract damages are special damages. All right? Okay. Final slide. We'll do this next class. It's 8 o'clock. Any question, comment?
Let's say I'm an employee and I have a regular income. Would that be considered consequential damage or special damage, like specifiable damage?
Well, so what happened to you? You couldn't go to work
Or something like that.
because of why? It depends on whether your inability to work was contemplated by the other side. Let's say it was your glasses and you couldn't work without glasses. And the optician or the glass shop knew that you couldn't work with the glasses. Okay, maybe. Right? But a lot of times when that happens, they'll give you something. They'll give you something that just barely fits your vision, right? Just like how insurance company gives you replacement car when the car is not fixed on time, right? Okay. Satisfied?
So
Okay.
as long as it's contemplated, it'll be
Yes, it will be recoverable.
okay.
Yeah. But it's not just actually it's not just actually contemplated, but also it has to be reasonable that it was contemplated. But then again, it's there's a whole universe of cases on consequential damages. There are just so many fights on that, as you can imagine. I mean, what was contemplated or what was reasonably contemplated, you can imagine there can be so many disputes, right? I mean, that example I couldn't answer with confidence. Yeah. So usually your job as a lawyer is to minimize those uncertainties as much as possible. So you write out what is recoverable. Yes.
So we can consider consequential laws as unforeseeable laws, and
Sure,
particular of a peculiar situation.
Okay, you can say that. You can say that. Foreseeability, I think, is a really important factor. Yeah. Any other question? Okay, that's it for today. I'll go over the last slide next week. That's the third remedy. And then we will go into the distributorship agreement. Okay. But as you do that, I'll send you actual distributorship agreement, sample distributorship agreement. Please read that contract. Please read that. Of course, read the slides as well. Okay. And we'll as soon as we do the agreements, as soon as I start lecturing, I'll keep referring to the clauses in the contract, in the sample contract I gave you. Okay? Thank you, and I'll see you next week.